Someone might need the services of the Public Law and Human Rights team when they want to challenge the decision of a public body, for example, local government, the NHS, schools or police. They may have made complaint and exhausted the complaints procedure, and they might want to get the matter before the court, for example, in judicial review, and that's where our team can help. The Mental Capacity Act came into force in 2007 to provide a comprehensive legal framework for decision-making for anyone 16 or over who's unable to make a decision for themselves. Before that, the law on capacity was a bit of a mishmash. The principles of the Mental Capacity Act are focused on empowering people and supporting them to make decisions for themselves as far as possible. An assessment of mental capacity should be time and decision specific. There are two parts to the test. The first part is the diagnostic test, so whether somebody has an impairment or disturbance in the functioning of their mind or brain, and whether that impacts on their decision-making ability. And the second part is, can the person understand the relevant information? Can they retain it? Can they use or weigh the information, and can they communicate their decision? When someone lacks capacity to make a decision for themselves, the Mental Capacity Act allows best interest decisions to be made on their behalf. Best interest isn't defined in the Act, but there is a checklist of factors that someone making a best interest decision should take into account, and this includes things like not making assumptions based on the person's age or appearance, trying to encourage the participation of the person where possible, and considering what the person's past wishes and feelings, beliefs and values were. There may be a dispute as to what is in the person's best interests. For example, family members might not agree about where their loved one should live, or there may be a dispute about serious medical treatment required by their loved one. Where there's a dispute, our team can help get the matter before the Court of Protection for the court to make the decision. Deprivation of Liberty Safeguards, known as DOLS, are a legal framework to protect the rights of people who lack capacity, who are placed in a care home or they're in hospital under a restrictive care regime and they're not free to leave. If the person objects, there's non-means tested legal aid available to challenge the DOLS. This is something our team specialises in. If you have any more questions about the Mental Capacity Act or DOLS, please do get in touch with me and my team.